What happens to ongoing contracts during the pre-insolvency phase? Can creditors terminate those contracts? The new Insolvency Law, Law 16 of 2022, incorporates the provisions of the European Directive 2019/1023. The essence of both regulations is to ensure the viability of business activities during the communication of the opening of negotiations with creditors. This essence can be summarized in 5 rules. Rule 1. The communication of the opening of negotiations with creditors does not affect contracts with reciprocal obligations pending fulfillment. Rule 2. Contractual clauses that provide for the termination or early resolution of contracts are invalid. Rule 3. During the protective period of the pre-insolvency phase, contracts necessary for the continuity of business activities cannot be suspended, modified, or terminated early due to breaches. However, those not necessary for the activity can be suspended or terminated. Rule 4. Contractual compensation agreements subject to Royal Decree 5 of 2005, which we will discuss later in this video, are not affected by the communication of the opening of negotiations. Nevertheless, any negative balance resulting from the compensation cannot be subject to judicial enforcement during the 3 months of the pre-insolvency phase. Rule 5. Supply contracts for goods, services or energy necessary for the continuity of business activities cannot be terminated early during the 3 months of the pre-insolvency phase. What about contractual compensation agreements subject to Royal Decree 5 of 2005? Royal Decree 5 of 2005 regulates the regime of contractual compensation agreements and financial collateral in Spain, aligning with European directives to strengthen financial stability. This decree focuses on 2 main areas: contractual compensation agreements and financial collateral. Contractual compensation agreements. These agreements allow the parties to offset reciprocal obligations to reduce credit risk. This is particularly relevant in insolvency situations, as it facilitates debt settlement and reduces exposure to default risk. The decree ensures that these agreements are valid and enforceable even in the insolvency of one of the parties, thus protecting the integrity of the financial market. Financial collateral. Financial collateral includes assets such as money, securities or credit rights offered to secure the fulfillment of financial obligations. The decree establishes a clear legal framework for the constitution, validity and enforcement of these guarantees. It emphasizes the simplicity and effectiveness of the enforcement process, avoiding prolonged judicial procedures. It also ensures the protection of the parties involved, even in insolvency cases, by allowing the immediate enforcement of guarantees. At Insolvency Law Procedure, we are experts in advising businesses and startups. We are committed to supporting the success and growth of your innovative company. Reach out to our AI assistants, Savvy and Athenia, to focus your inquiries, or contact us directly if you have a problem or project that requires advice. Find more information at ilpabogados.com and ilpstartup.com. Legal services are not a commodity. Seek the best, not the cheapest.